decide. And when you go out after that, oftentimes, in many instances, you simply decision together in the back room. You can't do that. So you reserve a lot of stuff that you don't need to reserve.
Doesn't sound like the most efficient use. All right. Thank you, everybody, for being here with us, and for everyone on Zoom. Thank you for your patience as we figured out some of the technology. Technology in the north is not always a forte, but Justice Watt was just sharing that it doesn't always work in the south either. So thank you guys for your patience. On behalf of the Law Society, I want to thank everybody for being here, specifically Justice Watt for taking the time to speak to the Nunavut Bar today. For a brief introduction, although I don't think Justice Watt is a man that needs much introduction. The Honorable David Watt is widely recognized as one of Canada's preeminent criminal law authorities. Justice Watt argued approximately 60 appeals in the Supreme Court of Canada and 1,500 appeals in the Court of Appeal of Ontario. In 1985, Justice Watt was appointed to the Supreme Court of Ontario. He is a prolific writer and the visionary and engineer behind the model criminal jury instructions in Canada. Many of us are very familiar with the Justice Watt's Manual of Criminal Jury Instructions, also the Justice Watt Manual of Evidence. So it's an honor to have him here with us and speak to us. In 2007, Justice Watt was appointed to the Court of Appeal for Ontario. He's a visiting professor at Osgoode Hall Law School at Dalhousie University and has lectured extensively at continuing legal education programs for judges and lawyers in every province and territory in the country. Finally, and specifically for the North, Justice Watt has a passion for hockey. In his youth, he played junior hockey in his hometown, and in his adult life, he has remained devoted to the sport and on executives of different hockey associations. So today he's here to discuss with us criminal jury trials, and I'll give him the floor. Thank you very much, Justice Watt.
Thank you very much for inviting me to share some thoughts with you about the conduct of the criminal jury trial. My vantage point is that of a trial judge, both from the actual position, which I spent a little over 22 years at, and also that of an appellate judge charged with the responsibility of reviewing other people's handiwork in the conduct of criminal trials. The criminal jury trial in this country is a work in progress. It has evolved and it has continued to evolve, albeit without compromise of the roles that its several constituents play. And the roles of Crown Counsel, the roles of defense counsel, the role of the trial judge, and the role of the jury. The trial judge as the trier of law, the jury as the trier of fact. As counsel, you create the evidentiary record under the guidance, obviously, of the trial judge who determines the procedure that you will follow, and also, obviously, the evidence that the trier of fact will receive, and from which the trier of fact will be asked to make its findings in accordance with the legal principles that govern those findings. The trial judge instructs, obviously, on substantive law, how evidence may or must not be used in a case, what the prosecution has to prove to establish guilt, the essential elements of the offense, maybe the mode of participation that the accused is alleged to have adopted and brings him or her before the court. And from the defense point of view, the available defenses, the available justifications, the available excuses that are either raised specifically by you as defense counsel or arise on the evidence such that there is an air of reality to them, and the trial judge has an independent obligation to put them before the trier of fact for their adjudication. And we know that the jury in a criminal jury trial really has got three separate functions. The first one, and for many the most important, is that the jury finds the facts. They find the facts on the basis of the evidence that is adduced at trial and on the basis of reasonable inferences from that evidence, most of which, in the great run of cases, is circumstantial in nature. It gives rise to a series of inferences. No single item of circumstantial evidence ever gives rise to just one inference. It gives rise to a field of different inferences that the jury are entitled to draw from that item of evidence considered together with the balance of the evidence in the case. The second job of the jury is obviously is to follow the legal principles that the judge tells them applies in the case, both in the establishment of the essential elements of the offense, which are the Crown's burden and must be met beyond a reasonable doubt, but also the use that may be made of various items of evidence. And in addition, trial judge has an obligation to explain in understandable terms to the jury any defense, any justification, or any excuse. I say understandable terms because trial judges talking to juries are engaged in a form of communication. And communication has three separate constituents. It's got an originator, the trial judge. It's got a recipient, the jury, and it's got a message. And it's no communication at all if the language used by the trial judge, and this goes equally well with the submissions of counsel, is not understandable to the trier of fact. Jury instructions, whether they be preliminary, mid-trial, or final, ought not to be composed in language that their ultimate consumer, the jury, does not understand. Otherwise, they might just as well have been composed in a language that no one on the jury understands at all. So the obligation of the trial judge is to explain the legal principles to the jury in terms they understand, and the jury are obliged to follow the trial judge's instructions, good, bad, or indifferent. It may be that in some years' time, when the court will say the trial judge made a mistake, left something out, got something wrong. But for the jury's purposes, that's the rule that they must follow. And their final obligation is to render the verdict that the law prescribes for the findings that they make from the evidence that they consider. The criminal jury trial, I suggest to you, however, is not a benevolent dictatorship. It's not the trial judge's exclusive preserve. It is in one area, to be true, the trier of the law. But otherwise, the criminal jury trial is a joint venture. It's a partnership of three, and each in their own way, whether prosecuting, defending, or trying, must endeavor to ensure an efficient and effective trial where the trial process is actually and apparently fair to all constituents and worthy of the public trust. Are current trials perfect? No, of course they're not. They're not always timely. They take too much time. They're overly and unnecessarily, I would suggest in many instances, complicated. Can we do better, even without legislative change? I think we can. And as council, you have a significant role to play in that improvement. Let me remind you, just looking around the room, of trials as they were when I began as a trial judge, which in many cases, if not most cases, with those of you present in the room, was before you were born. Pre-charge conferences, a common feature, or pre-trial conferences, a common feature, mandatory in jury trials. Unheard of when I started in 1985. There was no conference. There was no pretrial conference report. The trial judge coming into the case had absolutely no clue what the case was about, other than seeing the indictment and knowing what the charge was. Resolution discussions at pretrial conferences did not take place because no conference, no discussion. If there were plea discussions, they took place before the trial judge on the morning the trial was scheduled to start. Sometimes they worked out, sometimes they didn't. To tell a story about a legendary High Court judge in Ontario who was well known for bringing counsel in before the case to try and resolve it because perished the thought that he actually had to try a case. That was not on his agenda. Have an accused who's charged with murder, brings in the two counsel and says to defense counsel, what about a plea to manslaughter? Well, no, my client's defense is he didn't do it. And I'm sorry, I'm just not able to entertain any discussion of manslaughter. Well, he said, no, let me understand this case. I said, no, I understand the prosecution's case. There is a statement your client made, right? And the statement goes in. It's murder, right? So wouldn't it be in your client's best interest maybe to plead to manslaughter? Well, no, because I don't know where the statement's going to go in. Well, let's just assume that your statement is going in. And you want to think about that for a minute? Turns to the Crown, of course, who is now full of piss and vinegar, that knows he's got a winner murder case. Turns to the Crown, what about manslaughter? Oh, as your lordship said, this is an overwhelming case of murder. But it's based on the statement, right? Yes. And I'd have to rule on the statement, wouldn't I? And if I didn't admit it, do you agree you have no case? Now, gentlemen, let's go out and see if we can resolve this matter. That was his idea of a pretrial conference, extort guilty pleas. Pretrial motions, a time consumer in most current trials. Time was slightly before I started when the pretrial motions had to be done after you picked a jury. So you would pick the jury and then send them away for time indeterminate while the pretrial motions played out. And they were always a dress rehearsal for the trial. always done on the basis of testimony, never done on the basis of an agreed statement of fact or some combination of things less than viva voce evidence, even if there were really no credibility or reliability issues. There were, to be sure, fewer then, because many of the investigative techniques that produce them now were not in existence at that stage. But there were, for practical purposes, no pretrial motions in the sense of no motions in advance of jury selection. And jury selection itself was much different. There were peremptory challenges. The Crown also had the right to stand aside up to 48 jurors without giving any reason. As a prosecutor, prosecuting a few murder cases here and there, I never challenged a prospective juror, never had to use peremptory challenges. Challenges for cause were in existence, certainly, but not frequent. And we had no alternate jurors. We had no additional jurors. So the potential of a case cratering over a long period of time when the jurors were discharged and taking the number down to fewer than 10 was always a possibility. Fortunately, it didn't materialize in most instances. Mid-trial instructions, telling jurors a number of things about pieces of evidence that are in for a particular purpose, but not for another purpose. Evidence of limited admissibility did not exist. You waited until the charge to tell the jury about the limited use it could make of evidence that they heard several weeks before. Now, does that make a lot of sense? Not really, because the prohibited use in many instances is the use that you and I as lay people would probably make of that evidence. Bad character evidence, perfect example. How many of us in making decisions about various things in life, when proposal is made by someone, look at the person who's making the proposal and say, you know, is that a person that I could trust or not? So that evidence of bad character, propensity, people tend to act in accordance with their character. It's a natural form of reasoning for most people, whether it's good character or bad character. Yet back then, the jury didn't know about that until after all the evidence had sat with them, often for weeks on end, until they were finally given an instruction. Oh, by the way, you can't use that evidence for that purpose. You can only use it for a permitted purpose. There were no specimen jury instructions. You had no idea what was coming out of the trial judge's mouth in most instances when it came to the charge. There were no pre-charge conferences. You didn't discuss what the trial judge was going to say. You just listened to it, often trying to find some place to hide, having heard the substance of the instructions, and then made your objections, often not terribly well formed or well articulated, after the charge. The charges were given only orally. Jury heard it once. The language they used was legalese, basically parroting judgments of higher courts without any real regard to what the comprehension level of the jurors was. You were essentially displaying your qualifications for the Court of Appeal, not for the jury, who rendered a verdict that in the overwhelming majority of cases accorded with the evidence, but in spite of what you told them as the trial judge, rather than because or by being informed about it. So what can we do as members of the constituencies that go to make up a criminal trial to make it a little bit better. I suggest we might start with the pretrial conference. Pretrial conference is critical to the fair trial of jury cases. The input of counsel at a pre-trial conference is absolutely essential. They are familiar with their files, whether their brief is for the prosecution or their case is for the defense. They're the ones who know the issues that are likely to arise in the trial. And they're the ones that are, I suggest, are obliged to identify those issues, to state what their positions are on those issues, so that the presiding judge can compile a report or a memorandum to forward to the trial judge, so that the trial isn't a scavenger hunt. It's like Holiday Inn, no surprises. Will the trial judge get all of it right? Of course not. None of us do, despite our best efforts. But certainly to alert the trial judge to what the issues are in the case is an important function that both Crown and defense counsel need to come to grips with, as do the judges who preside on the pretrial conferences, in order to better prepare a case for trial and minimize the risk of error caused by uncertain events. It's also important for the purpose of scheduling trials to get them on the rails, to get the pretrial motions out of the way in advance of jury selection, to set the evidentiary record as best you can. No amount of human ingenuity can envisage everything that will happen in a criminal trial. The only thing certain about a criminal jury trial is its uncertainty. The person who presides in a criminal jury trial is like an emergency room physician. You have absolutely zero idea about what's coming through the door. All you want to do is to make sure as best you can that the patient doesn't die on your watch as a result of something that you do, or if you thought about it, you should have done. Courts of appeal are different. They're like forensic pathologists. The patient's already dead. They just sit there, three of them, not allowed out on their own, and look at the transcript and see whether something has gone wrong at the trial, and whether the something that went wrong went so seriously wrong that the trial has to be held again. I don't minimize the importance of it. I mean, obviously I sat there for a little over 14 years, but it's a very different mechanism than at trial. Some judges are more comfortable with appellate review because it's a fixed record and you don't go outside that, save in exceptional cases. Others are more comfortable with the spontaneity of the trial process, and they don't mind not knowing what's coming through the door. But you can minimize the surprises by, as counsel, conducting an informed pretrial conference with a judge of the court to identify the issues. Also, to take into account that with many of these pretrial applications, you don't need every witness. And many of them, credibility of witnesses and reliability of their testimony may not be much of an issue. And so what do you need the witnesses to testify for? Agreed statements of fact, even to some extent, will say statements, can form the basis in many instances or determinations of admissibility. So what you're trying to do is to set the table for the trial, to advise the trial judge of what to expect, and take your positions and get your positions put forward, whether you're prosecuting or whether you're defending. So the trial judge knows what to expect and is better equipped to make a ruling that's more likely to be accurate and correct than otherwise. What you need also to understand, and this goes a little further with respect to the pretrial applications. There's this popular bit of courthouse folklore that on a voir dire, an admissibility inquiry, you're entitled, as a matter of law, to call viva voce evidence. There's no case that says that, and there are cases that say the opposite. And in many instances, it is entirely a waste of time to be going through a dress rehearsal. The trial might be a Broadway play, but that doesn't mean that it has to go through a dress rehearsal on all the pretrial applications. The other thing to bear in mind as counsel, and it's counsel on both sides. There's no assigning of fault here. Counsel make too little use of admissions of fact. In many instances, you sit with a jury and listen to evidence day after day, saying stuff that really isn't an issue and simply doesn't matter to either side. So get rid of that stuff. The jurors are over there, half of them are half asleep or approaching automatistic status from listening to repeated evidence about the same inconsequential subject matter. Get rid of that stuff. Make the admissions. It doesn't harm your case. It gets the case down to the issues that count. And as far as pretrial motions are concerned, those motions, unfortunately, have become, in many instances, the sideshow that overtakes the circus, because many of them take longer to complete than the trial itself takes. I recall trying a murder, first-degree murder in Toronto. Two accused, killed a young woman doctor who just unfortunately happened to be in the wrong place at the wrong time. And the pretrial motions took 3 times longer than the trial, in part because one motion then begat another motion, which begat another motion, including a third-party suspect motion that required the attendance of police officers from a jurisdiction in province of British Columbia. But again, viva voce evidence, if you don't need it, don't use it. That's the time waster in many of these pretrial applications. Make sure that you give decent estimates as accurately as you can. Nobody can be unfailingly accurate, but as accurate as you can. But how long it'll take, how many witnesses, how long the argument's likely to take. Make sure the trial judge, it's the trial judge's responsibility, has some time to complete reasons for their decision at the time. And when the trial judge makes a ruling and determines, for example, that certain evidence of limited admissibility is going to be received at trial, take the time then to suggest to the trial judge, you know, Judge, you're going to have to give some instructions to the jury about how to use this evidence. Why don't we take the time now, when the jury hasn't even been selected, to decide what it is you should say about that evidence as the evidence comes in, contemporaneously with it. Some judges prefer to do it just as the evidence is about to be admitted. Others prefer to do it immediately after. It's 6 of one, half dozen of the other. The point is, when it comes in, tag it. as evidence that is of limited use. And you're going to repeat that in your final jury instructions as well. And for your own purposes as Crown and defense counsel, maintain a checklist. Trial judges, some of them at least, may provide you with a checklist. There's one in my specimen jury instructions book that you may find helpful. Just keep that with you as counsel. And when you see something that is going to require an instruction, put a little check mark so that when it comes time to talk to the trial judge about what goes in and what stays out of the jury charge at the end of the day, you've got a list there that has been compiled as the case unfolds. You can benefit from that at the outset, having been done at the outset even further. If you advise the trial judge, again, whether you're the Crown or whether you're the defense counsel, whether the trial judge asks you or not, as the evidence unfolds in the trial, when one of these witnesses is going to testify, give this evidence that is subject to limitations. Alert the trial judge to the fact the next witness is giving that particular evidence. So the trial judge then has available to him or her the instruction that needs to be given at that point in time. Let me say a few words about part of a trial that very little attention is paid to, because it's the first thing that the jury hears. First person to speak to the jury is the trial judge. Preliminary instructions to the jury. And most of them would put the average human to sleep. Where you sit, what times we sit, sort of a general outline of the procedure that's going to be followed. May say a few things about the assessment of evidence. And talks about, don't talk to anybody outside the courtroom, those sorts of things. You can take notes if you want to, you don't have to. We'll give you some paper and a pen if you wish to do it. But just put yourself in the position of a juror. You've just been chosen. You've never done this before. There are no job qualifications required, except you're the Asian majority, you're a Canadian citizen, and if there's been a challenge for cause, you've got through that. So you're there, and all you know about the case is what the registrar or clerk, depending on which you call them, has read out from the indictment. Jury had no clue what this case is about, other than an allegation of sexual assault, an allegation of second-degree murder, allegation of robbery. Do you think it might be appropriate to help the jurors out a little bit at the outset? Because they're going to hear a whole bunch of evidence. They don't know what goes with what. If you are able to give them some preliminary instructions about what it is the prosecution has to prove. For example, in a second-degree murder case, caused death, unlawfully caused death, state of mind required to make unlawful killing murder. What that does, and some jurisdictions it's called early issue identification, is it gives them some signposts along the road when the evidence comes in, to better understand the evidence and to better appreciate sort of what potentially goes with what. Trial judge will assist them on that issue at the end of the day by discharging their obligation to review and relate the relevant evidence to the issues. But it might help them at the outset to do that. Some other issues you're not going to venture into. You're probably not going to venture as a trial judge into what the defense position is. The instructions may change, the Crown's case may change, make it a lot stronger, or make it a lot weaker. So to go there at the outset is probably not a very good idea. But it is something to think about because it helps to inform the decision maker at the outset, to some extent at least, what this case is all about and who has to prove what. And of course, you would also instruct on the three basic principles: presumption of innocence, burden of proof, and standard of proof. And if your trial judges don't do that, I'd suggest in a discussion with them in advance of giving those instructions that you remind them of the value of doing so. As the evidence portion of the trial begins, keep in mind that the jurors will be watching you as trial counsel. Conduct yourself accordingly. No signs of impatience, no signs of displeasure, no signs of elation if something good happens to you. Because for every good thing that happens, there'll be one not so good thing that happens. So don't display any displeasure. And when you're questioning witnesses, particularly defense counsel, when it's your turn to cross-examine, be ready. Don't say, can I have 5 minutes? Can I have 10 minutes? That signals to the trial judge that you're really not sure what's going on here. And that's not a good sign also to convey to a jury. Avoid undue repetition in the elicitation of evidence. Don't editorialize, so you say, for example. Don't express any disbelief. You want the jury to believe what? That is a non-starter in any jury trial. Be clear in your formulation of questions. Formulate your questions in language that the jury understand, because even though the questions are not evidence in and of themselves, it's important that the jury understand what you're asking. And a question is not simply a statement where you raise your voice at the end of the question as if to put a question mark in the air. And cross-examination is not designed to reinforce the prosecution's case in the sense that if the jury didn't get it the first time, that when you ask the question as defense counsel a second or third time and the same answer comes out, the jury will get the message at that point. You have a position to advance. Cross-examine the witnesses in areas where you can elicit evidence in support of that position. Leave the rest of the stuff. Don't repeat the prosecution's case. Otherwise, they wouldn't call it cross-examination. They'd call it repeat or replay. And if you are, one other tip about examining witnesses, applies not so much to defense counsel as it does to the prosecution, but to some defense counsel as well. Some of the gravest mistakes are made in re-examination. The best re-examination I ever heard was, I have no questions in re-examination, because it is perilous to re-examine and elicit evidence on re-examination when it's out there with a full spotlight on it. That does nothing but damage the case of the re-examiner. So you tailor it to the circumstances of the case. Just don't repeat the prosecution's case in cross-examination. There is no percentage in that. It's poor marketing. As far as objections are concerned, Some counsel will say, "Oh, you know, my lord, I don't like to object in the presence of the jury." Well, okay, it's not it's personal preference. You just don't like to appear objectionable in the presence of the jury. You have an obligation. Some stuff, let it go. Doesn't make any difference. But the stuff that counts, you better object. Because if you don't, either you or another counsel will pay the price. Will be, was any objection taken at trial? And well, yeah, no, I didn't object because I don't like to do that in the presence of the jury because they think I'm trying to hide something. Most trial judges in their preliminary instructions will say something about. Sometimes counsel may object. They're not trying to hide anything, but there are rules that we have to follow. And nobody can be penalized or should be penalized for following the rules. Some defense counsel get quite vexed about the prosecution's leading questions. Leading questions are permissible in some areas. Don't object needlessly to leading questions in areas about which there is no controversy. That just moves the trial process along in an expeditious way. You know, is it something that's controversial where the form of the questions makes a difference or not? If it isn't, leave it alone, stay seated. When you get to the pre-charge conference, the cases make it clear that you have an obligation to assist the trial judge in finalizing criminal jury instructions. We see that Supreme Court of Canada cases. Daly is one, Rogerson is another. There are many that say the same thing. Concentrate in your submissions in the pre-charge conference on the governing legal principles. Those are the areas where the trial judge has to be correct. The appellate standard of review on legal instructions is correctness. And don't ask the trial judge to include in their final instructions that are that have no root in the evidence in the case that's being tried. Trial judge's obligation is to decant and simplify. The trial judge's obligation is to put to the jury those legal principles and those references to the evidence that are necessary for the jury to understand and to decide this particular case. This is the only case this jury is going to decide. So that's why the principles have to focus and the evidentiary references have to focus on what's here and now. Not some esoteric legal question that you might have had in law school. Not some dissertation, a circular tour around the area of the law that is governing, but something that is focused on this case. Let me give you an example. Street robbery, Court of Appeal from Ontario case a few years ago called Roe. Only issue, who did it? More particularly, was it the accused who was the robber? Trial judge opens the specimen jury instructions and sees the instruction for robbery. It's got stuff in there about color of right and fraudulently, because those are essential elements of theft, which is part of robbery. That doesn't matter here. This is a robbery, pure and simple. The only issue is whether Buddy is the person responsible. So you don't, it's not like, you know, picking up a work of fiction and starting at page 1 and reading to the end. You can skip parts. You leave it out. You say, look, I'm telling you, members of the jury, as a matter of law, that what happened here, if you accept the evidence of the victim, was a robbery. The only issue is, has the Crown proven beyond a reasonable doubt that Roe did it? And this is the evidence on that issue. So that's what I mean by paring it down, both the evidentiary references and your complaints at the pre-charge conference about what should go into the charge. Pick the portions of the evidence that's important. Make sure that's covered. The rest of it, for the most part, is filler. Got nothing to do with the merits of this case or whether the jury finds a verdict of guilty or a verdict of not guilty. There is a case that took place about 50 years ago in the Court of Appeal for Ontario about evidentiary references. It's a murder case out of Mississauga, R versus Demeter, went to the Supreme Court of Canada. There's some great lines in there about what judges have to do as far as the evidence is concerned. The failure to put a piece of evidence or to include a piece of evidence in a jury instruction will only be reversible error if that piece of evidence is the only evidence in support of a defense. Bear that in mind when you're asking the trial judge to put or to make evidentiary references in their charge to the jury, but be vigilant about accuracy and completeness of the legal principles, because that's the most important thing that the trial judge gives to the jury. Trial judges' evidentiary references, the jury, for practical purposes, could leave the room. They don't have to pay any attention to anything trial judge says about the evidence. But they do have to pay attention to what the trial judge says about the law. So he or she has to get that right. And your obligation as counsel, both prosecuting and defending, is to insist that they do so. Use a checklist. Beware of instructions that appear unduly favorable to one side or the other. It may seem like a great idea at the time, but if they're unduly favorable to the Crown and there's a conviction, that may end up resulting in a new trial, and nobody benefits by new trials. Similarly, if they're unduly favorable to the defense and their legal instructions and an acquittal results, that may equally result in a new trial. And that is a rule that you should keep in mind. Today's victory is tomorrow's defeat. So far as trial judges' conduct of the case is concerned, you'll run across some who are difficult to deal with. There is no excuse for that from the judicial perspective, but it does happen. But just take your time, keep cool, put your position forward in a respectful, meaningful way. That's the best you can do as counsel, and that's what trial judges hope to see. It's just that some trial judges see it as a one-way street. There's no excuse for it, but you'll run into it. You just do the best you can with the hand that you're dealt. Courts of appeal have ways of dealing with trial judges that conduct themselves in that way. They do it with two simple words: new trial. Happy to answer any questions anybody has. Thank you very much for inviting me.
much, Justice Watt. I don't know if there's any questions from the chair. Check on this.
Yep.
So a substantial portion of the field that what impact then that injury while charged with and now sitting on appeal while counsel while judges have to wake up. Why? Spoke a bit about, I guess it's a necessary kind of but appellate judges. A clock is not like all start forward and then fire.
Well, it's, the composition of appellate courts benefits from a mixture, but there's no question that there really is no substitute at the appellate level for a couple of things. First of all, you must have a firm understanding of what the appellate function is. And unfortunately, some don't always get that. And what they don't get is they put themselves in the position of the trial judge. And if the trial judge didn't make the decision that they made, therefore the trial judge is wrong. That's not the appropriate standard of appellate review. Appellate courts are not there to ensure that every T is crossed, that every I is dotted. There, as the Court of Appeal said in Demeter, there never will be a perfect trial. What you're there to determine is to determine whether, first of all, there has been an error, and don't make that assumption going in. Secondly, if there is an error, so what? It may be that there's no substantial wrong or miscarriage of justice as a result of that error. I had the benefit of over 2 decades as a trial judge. Certainly, without telling tales out of the back room of the Court of Appeal for Ontario, my approach to appellate review is much different than someone who has never been a trial judge, some of whom have never practiced law. You just sometimes, as an appellate judge, have to sit them down in the back room and say, look, this is how it really works. It's like the analogy I draw with them is it's like going to the dentist. Dentist says you've got a cavity and gets out the drill. And you think by the way the drill is going that it's a cavity that would rival the largest pothole on any road in the country. But when you look at it, it's about the size of a pinhead. When you shine the light on a specific aspect of the trial process at the appellate level, it takes on an importance that if you step back from the record entirely and say, yeah, it was a mistake, the big deal. That's where I think those who have been trial judges take a much different approach. Error identification often is easy. The more difficult question is the so what question. And there's no question that those who haven't been in the trial process view it, in my experience at least, others may have different experiences, entirely differently. Do they have valuable contributions to make? Yes, they do. But they really need to learn and be immersed in the trial aspect of cases to understand the process better. They have to be the emergency room physicians. You don't start out as a forensic pathologist telling somebody that they've made a mistake when you really haven't thought the matter through. So that's where I see the difference. I mean, the apex court is obviously in a different position. I've never sat there. I've sat in groups of 5. But you do notice that there's no question you notice a different approach. Absolutely. Some obviously variety. Sure, you need it. But I know trial judges look at the panel of judges who reverse them and say, what could I expect? Larry, Curly, and Mo were there. It's being unfair, but that's the way some trial judges look at it, especially those who have a lot of experience. That's not to say they can't make mistakes. Of course they can. Just take it step by step, and don't forget that important second step for intermediate appellate courts. Did it cause a miscarriage of justice or a substantial wrong? If it didn't, then this case is not going back or should not go back. Yep.
Hi, Justice Watt. Thank you so much for your presentation. I'm okay. I'm a third-year law student, so excuse my question if it's a bit naive, but I was wondering what your thoughts are on jury representation, whether a jury should represent, the community that the case is, tried in, or if it should be, Canadian citizens at large, and specifically maybe with Indigenous.
Well, certainly, I mean, the qualifications are provincial or territorial responsibility, so they vary somewhat. I mean, we had some difficulties in Ontario a number of years ago because of what we used to compose the jury rolls. We used assessment information, and you didn't catch any of the Indigenous communities in Ontario with that information, so they didn't get a chance to participate. We now use health card information, which seems to be fairly consistent across many of the provinces, at least. So at least they're capturing them. I mean, there will have to be some revision of jurisprudence from the Supreme Court of Canada about jury composition in order to have a jury composed of an accused person's peers. And the reason for that is there's an Ontario case, Kokopanas, or Kokopanas, however it is pronounced, that says random selection means random selection of the jury rolls, random selection of the jury itself. So, for example, there was a suggestion when the legislation was amended, when the code was amended to expand the stand-aside power. There was a suggestion by some that you should be able essentially to alter the composition of the jury by the use of the stand-aside power, simply by jumping over some of the jurors to get to others who may more fairly represent a diverse jury. Problem with that is that destroys the randomness aspect of it, which is fundamental to the composition of the roll and the selection of the jury. And the Court of Appeal, at least in Ontario, and I think they're the only one that's dealt with it, so you can't use the stand-aside power for those purposes. But look, we have diversity in our population. As long as they're otherwise qualified to be jurors, then there should be diversity in the juries themselves. The one thing we have noticed, though, and this is anecdotal from currently sitting judges, including my wife, that elimination of peremptory challenges has gone some way to producing more diverse juries, both in terms of origins, ethnicity, and language. So to that extent, it has changed the composition. We're getting younger jurors, more diverse juries, and hopefully that will continue, if necessary, by amendment, as long as they're able to understand the evidence, and even with interpretive assistance if necessary, then no reason for them not to be on juries.
Time for one last question.
For anybody else? Because I had a question, sir. We talked about admission. And what we do see is when you have a more experience, those kids from the defense.
Yep.
There are a lot. Because at the end of the day, this is the question. So for the younger lawyers who support the jury trials, how can a lawyer either from the defense and get to that and say to themselves, okay, yes, that I should admit. I'm not talking about change profession. But I think it's that fear of making that, or even Crown say, no, I want the witness to be heard because of what we have. How could that lawyer try to simplify, make those admissions not as fear?
Well, the big difficulty practically, there's a couple of difficulties. First of all, I think compared to when I practiced law, which is a couple of days ago, there's not the mentorship available on either side of the bar that there used to be, and it's as much of a problem on the prosecution side as it is on the defense side. You have, I've seen these folks prosecuting a serious homicide case. The prosecutor had no business being there. They haven't got a clue what's going on. And by the same token, on the other side, there's a fear, I think, on the part of defense counsel. And it's not an unreasonable one for a young lawyer, because many of them are practicing on their own, or maybe they're in association with others who have about the same amount of experience. They're scared to death of ineffective assistance counsel being raised at the appellate level. And we saw it would be a rare week in the Court of Appeal for Ontario, sitting on criminal appeals, where you would not see at least one claim of ineffective assistance of counsel. Most of them completely unmeritorious. But I think that's one of the reasons why counsel won't make admissions. And I'm not talking about, in most cases, admissions that for practical purposes are going to deliver the case into the prosecution's hands. A lot of factual issues that don't make any difference in the ultimate result can simply be admitted, because what cluttering the record with all this evidence does is it diffuses the narrative before the jury, so that the core of the case gets lost in this welter of inconsequential detail. And some of the Crowns are at fault for doing it. Trying a murder case of killing a husband and wife, murdered a child, and dismemberment of the body. I mean, there's no question that the body was dismembered. There was no question as to who did it. The dismemberment. And the Crown wanted to file 150 color photographs of the body parts. So on that, if we count 150 as the number of at-bats, and we count the figure I'm about to give you as the number of hits, 0 for 150. That's not it. Just get rid of that. There's this unfortunate tendency to to pile on the inconsequential, the stuff that's way away from the core of the case, takes up a lot of time and has got nothing to do but wasting court time and deflecting the issue, or deflecting the case from the issue. So I think there is that significant problem as far as defense counsel. And the real problem is where you've got one on one side who's extremely experienced and one on the other side who isn't. There is a real uneven playing field there, and it's sometimes a difficult field to navigate for the trial judge, because you can't seem to be helping out on one side because that's not your job. By the same token, sometimes you just have to call a halt and call in one case, one judge calling counsel in and saying, look, you're out of your league in this case. You need to get senior counsel. And to counsel's credit, he did. The case ended up having to be tried again. But there's a fear if I don't touch every stone all along the way, I'll be accused of ineffective assistance. I don't know that there's a single answer to that. I know we're trying through the Criminal Lawyers Association to develop a mentorship program that helps them out, but there's no equivalent on the Crown side, unfortunately.
So that you use the option grant.
Yeah. Yeah, Law Society, and then the Law Society has some assistance that way as well, not for the prosecution, but there's lots of prosecutors around that are experienced, so call them.
Thank you very much, Justice Walsh. Thank you very much for coming and speaking with all of us today. On behalf of the Bar and Law Society, just want to present you with a small gift.
Thank you very much.
Thank you very much.
Pleasure to be here. Thanks for having me.
Thank you. Still more pizza, cookies, and drinks too. Please grab some more. Thank you very much.
Thanks so
That's
much.
very interesting.
Nice to meet you. It's Justice Sarah's daughter. That's her. I have to speak to her.